Rich Lee, CEO and co-founder of New Era. I'm going to take my time today to talk a little bit about why New Era applies to every single person in this room, and why it's truly better for everybody involved in litigation. But first, who are we? What do we do? Our mission's pretty straightforward, right? We are building and we have built the most accessible, least acrimonious, most efficient dispute resolution platform ever. And it's because all of us have actually experienced this pain firsthand. So, we're ex-general counsel of venture-backed tech companies, but we're also all early-stage operators in these tech companies, having built and scaled, 3 different ones, and we're backed by some, incredible investors. But what exactly, are we solving here? So the problem is that, when we hear the word lawsuit, we automatically just assume it's going to be a 12 to 24 month, 36-month process, cause hundreds of thousands, millions in fees, and this is kind of the underlying assumption every time you deal with a legal dispute, right? And the reason why this is because all of our traditional venues, the court systems, traditional arbitration platforms, right, they're built for what we like to call the top 5% of litigation, right, which is your high stakes, highly complex, trademark or IP infringements, mass tort type cases. And yet nothing's been built for, the bottom 95%, which we actually call the core 95. This is where litigation happens, right? Your typical employment claims, consumer issues, breach of contracts, you're a SaaS company and your clients aren't paying your invoices. All of these things are the things that we actually deal with most of the time, and yet all of it goes to, right, that top 5% process. And so what happens, right, when these are the only options available? First, when you're trying to hold a company accountable, if you're an employee and a company's wronged you, or you're that SaaS company, you want to collect on hundreds of thousands in back invoices that people didn't pay you. The advice is almost always, just walk away. It's not worth it, right? Juice isn't worth the squeeze. It's not going to be worth spending 12 to 18 months fighting this thing, getting that court order, and going and enforcing it, right? And similarly, and companies are a big target for this when baseless claims are made against you, right? Wrongful, employment claims, right? That frankly are not meritorious, and other, kind of just mishmash of other claims where you want to defend yourself, and yet what's the approach? The approach is typically, just settle. And I've given that advice many times as a former GC, telling my team we would win, but just pay the guy. And so all of this is because no forum exists for that core 95%, and that's what we fill, right? So New Era is 100-day arbitrations. We also do mediations, all for one flat fee. Even though it's 90% faster and cheaper, the same quality arbitrators and mediators, still humans in the middle that you would find anywhere else. All of it on our platform that we built in-house that actually facilitates a ton of collaboration, and just cuts down process time, with AI just very thoughtfully layered in. We're taking advantage of the fact that, in our vertical, we don't need to rush into AI kind of as quickly as in some other verticals. And so while we all kind of use AI very heavily in the company, in our personal lives, this is something where we can kind of leg into it and create a lot of efficiencies and frankly just make the entire process far more accessible, far more efficient, and just frankly more enjoyable. And so the results are actually game-changing. These are a couple examples. So a major bank, they tried to put together a really customer-friendly program, really wasn't working out that well. Customer satisfaction was down. They were still snail mailing stuff to the mediators, to the customers. They moved it onto our platform. By the way, everything was taking minimum 3 to 6 months to resolve. On our platform, things were getting done in less than 30 days. Customers were happy. They could move on with their lives. And the bank's getting a level of reporting from our platform that they'd never gotten before. Similarly, a lot of companies using us to actually go pursue those unpaid invoices, go pursue other claims that frankly in the past they used to charge off, right? And so the past used to be, the proposition was 12 to 18 months. That's generally what they were banking on. Typically they didn't pursue it because of that. And so they were just charging these off, walking away from very legitimate claims. On our platform, getting results in less than 40 days a lot of times, enforcing it in court, getting the corresponding court order shortly after that, and now actually having a chance to go pursue these actual funds. And so in some cases, literally turning legal departments into profit centers. But also more importantly, accessibility is shining through, right? That same bank, all these customers were pro se, unrepresented, really difficult process for them to navigate. Suddenly they're getting results, going back to their lives, 70% faster. And then what's exciting to us too is that we've seen pro se individuals actually file arbitration claims against large companies, and they get their results and they get a resolution actually inside of 60 days because there's no games to be played on both sides. And so we see this as just a very exciting kind of access to justice benefit right to this platform. And kind of one last story. So among all of our clients, we're also the official arbitration provider for the U.S. Olympic Committee, Team USA, the U.S. Anti-Doping Agency. So these are high-stakes disputes involving literally Olympic team selection, Olympic competition, doping cases. The U.S. Olympics really wanted something that was way more accessible for their athletes because they also recognize that most athletes aren't Simone Biles or Michael Phelps. They can't afford an attorney, so most of them were still showing up pro se. And yet it was a really difficult to navigate process. Fast forward, they moved there to New Era a couple of years ago. They've since expanded their work with us, but now everything's getting done far faster, and more importantly, the cost to the athletes has been reduced by 70%. And so I said earlier, New Era is better for everybody, right? And so I'm just gonna kind of quickly run through exactly how, right? And so for individuals, I was talking about this earlier, pursue those claims. You've been wronged, pursue it. You're not gonna be bullied by parties with deeper pockets. So you don't have to walk away from these cases. You don't have to accept that outcome that you didn't want. And so your outcomes improve. For organizations, go defend those meritless claims. Don't just settle those anymore. You don't even have to engage in settlement discussions. I know most of the cases I settled in the past, I never would have engaged if I had New Era. And then more importantly, cost effectively actually go pursue the claims that you need to go pursue because there's tons in receivables as an example in so many of these companies. And so again, improving outcomes. For defense firms, we have a lot of AmLaw 100 firms and a lot of AM 200 firms, partners in these referring customers to us and converting them over to New Era. But a lot of them are actually going further because they realize that when cases are done on New Era, because there's cost certainty and time certainty in that 100 days, they can actually take these on. And they can take on kind of that core 95% of that portfolio from their customers and not just the high stakes stuff. So this actually adds to their book. More importantly, it gives a lot of associate training opportunities, which is kind of increasingly more important nowadays. Sorry about the typo. And then lastly, for plaintiffs' firms, right? A lot of times these plaintiffs' firms are walking away from a lot of claims and a lot of clients that they really want to be able to help out, but the math doesn't work out, right? When the contingency fee is X and it's for 12 to 18 months of work, a lot of times you just can't do it. But when X is now for 100 days, you can take on all of these cases and you can actually help all of these people and improve your business, right? It flattens out and streamlines your revenue, makes it a little more predictable. You could still pursue your big cases. But more importantly, it kind of just allows people to go back to why they became a lawyer in the first place, right? Which is to help people. And so all of these benefits are available simply by changing contracts. That's how you adopt New Era, right? So at the end of every terms of use you've ever clicked through, any contract you've ever signed, there's always a clause that says if we have a dispute, we will resolve it in the courts in Austin, Texas, or some traditional arbitration forum. Cross that out, put in New Era in all your templates. That's free to do. You've adopted it, and you've gotten all these benefits. And so, more importantly, the industry is joining fast. You're in good company. We're growing fast. Customers are increasing their use of the platform. And so my ask to you is simply, choose a way more affordable, way less acrimonious, and more efficient dispute resolution. Thanks.